Thanks very much for joining us for episode 13 of InTek Freight and Logistics, the podcast. I'm Kevin Baxter, and I'm joined by my co-host for this edition, InTek CEO Rick Lagore. On this episode, we look at transportation and logistics from a legal perspective, with one of the nation's top attorneys specializing in the field. Let's get started. Beyond the shipping challenges of the day, transportation and logistics professionals must keep abreast of various legal issues that may arise to ensure they stay on the right side of compliance and avoid being blindsided by the unforeseen. Enter our guest for this episode, who specializes in transportation and logistics law, to provide updates on a few recently developing issues. We welcome Marc Blubaugh, partner with the Benesch Law Firm. Marc, thanks very much for joining us today.
Well, thanks for the invitation, Kevin. I'm delighted to be here.
And we are delighted to have you. So first off, tell us a little bit about yourself, what got you into the profession and what you do right now with Benesch.
Sure. My first kind of introduction to the world of transportation and logistics was in the late 90s. I was practicing law already, but I got involved in a case involving a shipment of shoes that was coming from Brazil to the U.S. And when it arrived in the U.S. and was opened at destination, it was empty. And there was a few $100,000 worth of shoes, and they were all missing. So there was enough to fight about, and every party who had ever touched that box ended up getting sued in federal court. So there was a Brazilian warehouse operator, the steamship line that brought it across the ocean, the railroad that took it from the port inland, a trucking company that took it from the rail ramp to final destination, and then our client was an ocean freight forwarder who had coordinated the entire move. And so for me, it was this wonderful introduction to the world of multimodal transportation and the unique federal statutes and international treaties that govern this area of law, and thought, this might be an area where I could not only distinguish myself as a good lawyer, but that we as a firm could distinguish ourselves from other good law firms. So one of my colleagues and I began to build the practice at that point in a robust way, and we have been off to the races ever since. And it's been a fun ride over more than 20 years now. And we've been fortunate to be recognized by a number of the credentialing authorities. U.S. News and World Report has recognized us as the transportation law firm of the year for 2023. It's, I think, the sixth time we've received that distinction in recent years. They choose one firm in the entire country to receive that recognition. So we're really proud of that, as well as a bevy of other accolades that we've received from various credentialing associations that really base their credentials on feedback from our clients and from our peers. It's been a great time with a neat industry.
So what came of the shoe case then?
The ultimate conclusion, well, it did get settled before we went to trial, but I think that the likely fact pattern was that the shoes were actually stolen in Brazil before the container was sealed. There were a number of factors that kind of led to that. And so essentially an empty container had been transported all this way from Brazil to the U.S., but the parties did reach an amicable resolution.
So that's one case that kind of got you into it. Nowadays and, in recent years, what are some other types of cases that you handle through your firm? And are you representing kind of anybody involved in transportation, whether it's, shipper, broker, carrier, et cetera?
Yeah. It's interesting. I started out primarily as a litigator, but my practice has developed over the years such that I spend a great deal of my time on non-litigation matters. So I would characterize my practice, and really our practice here as a firm in the transportation industry, is very much hybrid. I spend a lot of time simply helping clients solve problems at the end of the day that they are facing in connection with the transportation and logistics. And those could be contractual issues as they begin to develop and negotiate new relationships with one another or with customers, regulatory issues that those in the space end up having to navigate in some fashion, a lot of just general business advice as companies begin to grow and morph and add services or drop services and adapt to the ever-changing landscape, facilitating transactions, lots of mergers and acquisitions and consolidation in the industry, and of course still litigation. but our practice is structured the same way. Now, unlike me, I have a very hybrid practice. There are other members of our team that are siloed more, let's say, certain attorneys who do nothing but transportation contracts, drafting and negotiation and the like, and then others who are exclusively in litigation. But I've enjoyed the hybrid kind of trajectory of my practice because it does permit me to serve as outside general counsel to a number of our clients, also for some trade associations. I serve as the outside general counsel for associations like the Transportation Intermediaries Association. I'm also outside general counsel for the Intermodal Association of North America. And I've had the privilege of serving in some neat positions for other professional associations. I'm a former president of the Transportation Lawyers Association, former president of the Columbus Roundtable of the Council of Supply Chain Management Professionals, and the like. So that's kind of the range and breadth of the practice. And then in terms of other litigation-related disputes, it's everything from high-dollar cargo claims, freight charge controversies, insurance coverage-related disputes, trade secret and employment-related controversies. It's the full gamut. We intend that our practice to be a one-stop shop for both the providers of, but also sometimes the commercial users of transportation and logistics services. So it's a lot of fun, and we have a team that we're really proud of, a number of whom have come from the transportation and logistics related industry, perhaps as a former general counsel of a trucking company or an in-house attorney at a large warehouse operator. We have a customs broker who's also an attorney, helping us with international trade and trade compliance related issues. So it's an exciting time to be involved in this practice.
Absolutely. And thanks again for joining us and sharing the practice and what all it does. And congratulations on all the accolades it receives. We've been following and staying connected with you for a long time. So really appreciate you coming on. In terms of the legal issues, I mean, we've seen a bunch of them come across, and we're going to try to do a kind of a rapid fire of questions. But one of the first ones that comes across is on the FMCSA's definition of, industry positioning in terms of brokers, bona fide agents, and dispatchers. Can you tell us a little bit about the guidelines that just recently were released?
Sure. Yep. Those just issued last week, as you noted. And in fact, we issued a bulletin that same day about this very issue. What are the definitions of bona fide agents and brokers? So, I wouldn't say there's been any kind of transformational change in terms of the definition. The agency said essentially, hey, we're sticking with our current definitions, but we're going to put a little bit more color on what those ultimately mean. And so, for instance, with bona fide agents, keep in mind, we're talking about agents for motor carriers, not agents for brokers. So I think there is a little bit of a misconception already in the industry, just based on the issuance of the guidance last week, that this restricts a freight broker's ability to deploy an agent model. And that's not really the case here. What we're talking about are bona fide agents of motor carriers. And the agency made it clear that there are some collars around that. And it's really kind of boils down to the fact that the definition means what it says, that when you're talking about a bona fide agent, you've got to, generally, you're not going to be serving more than one motor carrier, that you don't have the ability to exercise discretion and allocate loads among several motor carriers. There are some limited exceptions to that FMCSA acknowledged. They said, well, it might be possible that a bona fide agent could be, serving a number of motor carriers. But if that's the case, that agent can only do so if it's really impossible that a given load could go to both of the motor carriers. So there might be a geographic market, for instance. Maybe this load is moving somewhere on the West Coast, and the two motor carriers that this agent serves, one of them is on the West Coast and one is on the East Coast. So they know the East Coast motor carrier wouldn't be able to help. So that might be an example. Or it might be that, it's a refrigerated load, and carrier A, for whom the agent works, handles reefers, whereas carrier B does not. And so they know, okay, I can only give this to one carrier anyways. So it does create a tiny bit of flexibility in that regard. But that's kind of the main takeaway from the guidance that was issued last week. The other big part of it, I suppose, was the role of a dispatch service. This is something that has befuddled the industry for some time. What is a dispatch service? That term is used in different ways by different people. And FMCSA, again, acknowledged, hey, there's not a statutory or regulatory definition of what a dispatch service is. So we at FMCSA, we can't just come up with one. They said, Congress wants to give us that authority. That's fine. But what FMCSA did say is that, you've got to stay within the definitions that have been set forth about brokers, carriers, and bona fide agents. So there are a number of factors that the agency, or in theory a court, would look at to evaluate whether a given actor that might call himself or herself or itself a dispatch service, whether they are in fact a broker or are they perhaps a bona fide agent. And that'll all turn on exactly what they're doing in a given situation. And there's not, one single absolutely determinative factor in that regard. But if you had to look at these factors and think about them, control, again, is probably the lodestar to think about. So if a carrier has a lot of control over a given dispatch service, well, it's probably more likely that that dispatch service is not going to be treated as a broker because it's just working for that one carrier under its direction to help it dispatch loads. Now, if the dispatch service exercises broad discretion with very limited control from that motor carrier for whom it is supposedly working, and it is allocating loads, well, that looks a little bit more like what a broker does and would be more likely to require broker operating authority. So I wish there was a real clear answer to the questions, but that's kind of fundamentally what the FMCSA said last week. Does that make sense?
Makes complete sense. That's what we kind of got from it, which was the main point was, can the agent or the dispatcher, are they making a determination, or do they have the freedom to go ahead and put it on a particular load on any of the carriers that they're representing, was the general takeaway.
Correct.
So another issue that's been big of late and even maybe crossed over a little bit with some questions about the definitions is fraud in the freight industry. You mentioned that you work with TIA, and we had President Ann Renke on here on the podcast actually a few episodes ago talking about broker fraud and double brokering and those practices. And one of the frustrations that people have been dealing with is there hasn't really been a lot of legal recourse when something is occurring. So is there anything new on that front or anything on the horizon that you're seeing in terms of preventative measures out there?
Right. Well, there's no question that we have a plague or epidemic of fraud in the industry, and it comes in all forms. There's imposter carriers, there's fraudulent pickups, there's unlicensed brokers, there's malefactors on the internet masquerading as legitimate brokers trying to get shippers to reroute payments to them. And then there are a lot of those, maybe what I would characterize as fraud adjacent activities, like double brokering, which in certain circumstances can involve a species of fraud, or hostage freight situations, which likewise can, again, at times involve a degree of fraud. So it's this one of these dangerous features of the current marketplace, and it affects everyone. And there's no easy one solution fix, because these fraudsters frankly, they're wily. Their schemes are varied, and they're ever adapting. There's a few things that can help, and what I tell clients, at least, might sound like a little bit of common sense here, but a bit of extra care and attention on the part of everyone in the industry could really help clamp down on some of this stuff. So, for instance, I've seen clients avoid these situations where they are paying very close attention to something like an email address. There can be subtle differences in email addresses, adding or deleting a single letter, an S in the middle of an email address, for instance, where an imposter is trying to step in as a legitimate carrier. Watching out for domain names, looking out for a gmail.com. Not that gmail.com is necessarily, the haven only of bad actors, but you might be used to dealing with a carrier that's really has a domain of just .com. And instead now you're seeing gmail.com. Well, that might be a red flag there. Doing things like contacting when you're onboarding a given carrier or a co-broker, contacting them at the telephone number of record with FMCSA, which only takes a second for you to look up on the internet, rather than at the number on an email signature block. That can help if you're dealing with an imposter. It won't always help if a new fraudster has just set up a legitimate company, but at least it helps with some of those imposter situations. Scrutinizing certificates of insurance. And you may use a vendor, whether you're a shipper or a broker. Otherwise, different parties may use a third party to scrutinize those certificates of insurance to make sure that they're not doctored, to ensure that you're receiving, at least at the onboarding stage, a copy from the insurance broker rather than necessarily from the carrier rep. It's hard to implement in practice, I recognize, if you're onboarding carriers at very high velocity, but to the extent you can, it's helpful. Being cautious about certain intermediaries who are not licensed brokers, but profess to control the freight of others. And we kind of alluded to dispatch services a moment ago. There can be genuine shippers agents that can do this as well. So some of this may be legitimate, but just exercising due caution. From an enforcement perspective, FMCSA, frankly, could help chill some of this activity if it were, in my opinion, more robustly enforcing existing law instead of what amounts to virtually zero enforcement in many respects. There is I'll give you one example. There's a national consumer complaint database. And this is something that was set up more than 10 years ago for industry stakeholders to be able to report cases of unlicensed activity or other, fraud-related matters to FMCSA. There are, I think, upwards of close to, if not over, 80,000 complaints that have been logged into that database over the years. And I don't believe that FMCSA has actually taken any action with respect to any of them, which seems, frankly, quite remarkable, but it just hasn't happened. Now, I'm not saying that every one of those 80,000 complaints is legitimate and clear and actionable, but one would believe that there'd be something that the agency could have done in the interim. So having some more action on that front would be most helpful. Law enforcement, it's hit or miss when you're dealing with this in various jurisdictions. California has a very active group that helps with cargo-related fraud and the like, but most states and most local jurisdictions, law enforcement looks at this as an economic crime and of a lower priority than some of the other crimes and demands that are pressing upon their time. So it's very difficult to get law enforcement involved in a robust way. So I think, from my perspective, guys, that it's kind of collective industry action and awareness that is going to be the more immediate solution here, while we hope and press the government for more action at the federal level. And I imagine that Anne, for instance, when we interviewed her recently, kind of reviewed some of the things that TIA is doing, which I know, it's exploring whether it can aggregate and anonymize certain data that might be helpful for the industry to see. There might be, or there is, in fact, a kind of a subgroup of the Highway Logistics Conference at TIA that has created a kind of avoiding fraud related course for TIA members that's based on some industry research that a working group had conducted a while back to help kind of highlight these red flags that I was alluding to earlier, or those types of red flags. The organization, the association, as well as others, have taken time to testify in front of the House regarding some of these issues. I know that TIA and other associations have been meeting with, having conversations with the current FMCSA administrator, Robin Hutchison, and kind of addressing at some length the impacts of fraud on this industry, as well as the frustration that I also have experienced regarding the fact that FMCSA hasn't done anything in a robust way to address this. Hopefully FMCSA is going to take a new tack while they're modernizing the agency, and they can do some more on the front end too, perhaps, by making sure that they have their eyes on the manner in which various players are registering for operating authority. Is perhaps a little more scrutiny warranted if the same address is being used for hundreds of operators. There might be legitimate cases for that, but certainly should be a red flag. So that's, those are a couple of the things that come to mind for me, at least, on the fraud front. And I would encourage your listeners to stay active, be engaged with the various trade associations, because if you look on the internet, there are lots of lively discussions about, what might be done to address these situations from a kind of practical day-to-day operational perspective. So those are a couple of my thoughts on the unfortunate situation involving fraud in the industry.
Yeah, and in terms of a lot of the conversations about this online, it's a little bit confusing in some manners because it's to shippers anyway, because there's the term co-brokering and double brokering, which confuses shippers.
Yep.
And the other thing that confuses shippers is that if they go ahead and find themselves working with a fraudulent broker, they end up paying that fraudulent broker. And then all of a sudden, later on in life, down the road, the actual underlying carrier that moved that freight for them comes knocking at their door and says, "Hey, I need to get paid, and here's the reason why." And there's legal case law that supports this, and then they get frustrated because they are caught in a situation that they're double paying and they don't understand why. Is there some more you can add around that? Yeah,
you're spot on in all those. Let me break it up in two ways. One is about the distinction and meaning of the terms co-broker, double broker, et cetera. So there's a lot of misinformation out in the industry on this topic to begin with. So the term double broker has a very negative connotation, inappropriately so, because it's typically used to describe someone who is engaged in what amounts to co-brokerage, but either without operating authority to do so or without contractual authority to do so. There's nothing inherently wrong with two legitimate brokers engaging in a transaction. Certainly nothing unlawful about it. It may or may not violate a contract term. So, for instance, if a shipper hires a broker and in that broker-facing agreement says, "Hey, you cannot co-broker, double broker, rebroker any loads that we tender to you," notwithstanding the fact that that's a broker could lawfully do with its license, that broker should only be tendering to carriers, not to another broker, because it has a contractual commitment, not a regulatory commitment or a contractual commitment to its shipper to do that. But there's nothing unlawful about that kind of activity. The problem comes in where that carrier has received a load and it, without operating authority to co-broker and without contractual authority to do so, double brokers to another carrier or to another broker. And that can lead to all sorts of practical consequences, and it certainly creates significant legal exposure for the motor carrier that has engaged in that activity, because under MAP 21, any party involved in unlicensed brokerage is subjected to either a $10,000 civil penalty for violation, or can face civil liability in a federal lawsuit from a private party, which might be a competitor, a disgruntled shipper, or anyone else, for any damages that arose from that activity. And here's the kicker, that liability is not only the company's liability, but it is imposed upon jointly and severally with the officers, directors, and principals of that business. So there is a tool available to go after those bad actors. The question is, can you collect from them? But moving to the second piece of things, in terms of the shipper paying twice, there is a body of law, and it's a split body of law as to what a shipper's obligation is when a broker or a carrier defaults on its obligations and has tendered that load to another carrier who performs the actual transportation. And so it depends on the jurisdiction in which a party finds itself as to what extent one body of law or the other will apply. And it will turn on the facts as well. What's reflected in the party's contract and what is in the bill of lading? Was it a prepaid bill of lading? Was this a collect notation on a bill of lading? And what role or what knowledge did the shipper have about the fact that these loads were being handled by somebody other than the party with whom they contracted? So I wouldn't encourage shippers to roll over immediately whenever they receive one of those demand letters. They need to evaluate the facts. They need to evaluate the applicable law, because again, there is a split in the courts about what kind of assumption of risk is being assumed and what kind of quasi-strict liability might apply in other circumstances. So it is a fact-sensitive inquiry. And if you get one of these letters from some of the more renowned collection agencies out there, like a Baxter Bailey, frankly, some of my typical advice is, throw that first demand letter in the trash and ignore it, and see if it ever does get escalated. It depends on the amount of controversy and the annoyance that may be imposed upon the business by virtue of this kind of dunning and collection-related activity.
So speaking of liability, another case, a different kind of liability, high-profile one that's led to a settlement late last year was Miller v. C.H. Robinson. For those unfamiliar with the particulars of the case, tell us a little bit about it, and then whether that outcome that was reached does affect the broker liability in terms of whether a carrier it hires is involved in an incident.
Sure. No, I appreciate that. So in this Miller case, a large shipper, Costco in that case, tendered a load of goods to a broker, C.H. Robinson, who in turn tendered it to a motor carrier. And the driver lost control. He was driving in icy conditions. This was out on I-80 in Nevada. He crosses over the median, smashes into an oncoming vehicle, gets pinned underneath it. The driver of that vehicle becomes a quadriplegic. He sues everyone involved, so among others, the broker, C.H. Robinson in this case, claiming that the broker chose an incompetent motor carrier. And this was brought in federal court. And at the district court level in Washington, the court originally concluded that the claim against the broker was preempted by federal law, as a statute called the Federal Aviation Administration Authorization Act, the shorthand that we all call it as the F4A. And as a result, the district court kicked the case out as against the broker. It's a case over against broker. Several other courts around the country had reached similar conclusions in comparable cases, but the plaintiff in that case appealed. And on appeal, the Ninth Circuit Court of Appeals, and the Ninth Circuit, for your benefit, it governs a number of states out west, so California, Washington, Oregon, Nevada, Arizona, Montana, Hawaii, Alaska. That Court of Appeals reversed the lower court and said, on the one hand, we agree that the scope of federal preemption in favor of brokers is very broad, and that the F4A statute would have typically preempted a personal injury lawsuit of this nature against a broker. But, the court went on, there is also a statutory, what they called safety exception in the applicable federal statute that meant that the claim was not going to be preempted. In other words, the case should and could go to a jury to decide in that instance. So it was a bad outcome. There was hope that the U.S. Supreme Court was going to review the Ninth Circuit's decision last year. Unfortunately, we learned in the summer that the court declined to review the case. It was one of the last decisions that the U.S. Supreme Court made before it started its summer. And as a result, we now have appellate courts continuing to evaluate this very issue. To what extent is a broker exposed to these personal injury claims, which can result in multi-million dollar judgments. I mean, we've all read about, heard about the unfortunate upward trend in favor of multi-million dollar nuclear verdicts against the transportation and logistics industry. And we've also seen the expansion of freight broker liability in recent years, and the appellate courts are continuing to wrestle with this. I'll tell you, we are all eagerly awaiting a decision from now the Seventh Circuit Court of Appeals. This is in Illinois. The Seventh Circuit covers Indiana, Illinois, and Wisconsin. And this case is called the Ying Yi case. It is a case involving the very same legal issue. What is the scope of this so-called safety exception in the F4A? And does it or does it not carve out freight brokers or preserve the power of preemption as to freight brokers? That case, the Ying Yi case, was argued in the Court of Appeals in early December. Here we are, we're almost into early July before we know it, and still no decision. And every other case that was argued that day in Illinois in the Court of Appeals has already been decided. So this is the last one, and it could come out any day. It could come out later today for all I know. But we're keeping an eye on that because it'll be informative whenever it does issue. Just as another little point of information, there was another decision in the 11th Circuit, which covers 3 states, Alabama, Florida, Georgia. It issued a favorable decision just a couple of months ago in April. And it was a cargo case, not a personal injury case, but it was very instructive, I think, for personal injury cases in the way that it viewed the safety exception. So a much more favorable outcome in the 11th Circuit. So, all of this has the effect, though, on our industry here of some creating uncertainty. It has an effect on insurance premiums. It can lead brokers to try to implement interim cures of all kinds, sometimes cures that are worse than the disease itself. Maybe brokers begin to adopt complex or unwieldy carrier selection protocols that are not fully supported by compelling data. And they begin assuming duties that shouldn't otherwise be imposed on them by law. So there can be all sorts of other consequences. But we're hoping that there'll be some further clarity when the Seventh Circuit issues its decision. And in the event that it does issue a broker favorable decision, and in the event that the plaintiff appeals that decision to the U.S. Supreme Court, it's more likely that the U.S. Supreme Court will, in fact, look at that issue now because there is going to be a very clear split in federal circuits. And that's one of the factors that the Supreme Court uses to evaluate whether or not to review a given case. Will it resolve a circuit conflict? So we shall see.
One more issue that we'll hit on briefly here that's still out there as well. This one's more towards the ports in a way. There's been some ongoing conflict between brokers and ocean carriers regarding detention and demurrage fees. Overcharging has been an issue. Where do these concerns stem from, and what's it looking like the Federal Maritime Commission is doing to address it with its rulemaking?
Sure. Yeah, I mean, it's clearly, this is an issue that's on the minds of many. And it's not a surprise when you think about the extraordinary volume of goods, manufactured goods in particular, that are moved on a container, and the nearly 100 million drayage moves that are performed annually, and all of the millions of truckload moves. Drayage is a huge component, a huge sector within the greater transportation market. So 2 things to keep in mind on this front. One, last year, just over a year ago, it was June 16th, that the president signed into law the Ocean Shipping Reform Act of 2022. And the goal was to kind of increase efficiency at the ports, improve competitiveness and costs for U.S. companies and consumers, and addressed a variety of other things as well. But that act also said, look, with detention and demurrage, there's some special new rules that everyone needs to abide by. And what the statute did was identify 13 data elements that any ocean carrier or NVOCC needs to include on an invoice for detention or demurrage, ranging from everything, the date that the container is made available, to the allowed free time, to what the end date of free time is, email, telephone number, other contact information for questions about detention, demurrage, or for mitigation. So there's a whole variety of things that need to remain on an invoice or be included on an invoice. And if it's not, the statute says, well, if you fail to include that information on an invoice with detention or demurrage charges, you have no obligation to pay. So whether it's a shipper or a motor carrier, they don't need to pay those invoices. And FMC itself can impose penalties and demand refunds and do things along those lines. There are, various mitigating provisions in the statute. If you're an NVOCC and you're truly just passing through things on and disclosing that, you may not have the same exposure. There's a bit of a safe harbor, but that law became effective immediately. It was self-executing. But what's happening at the FMC that relates to detention and demurrage is there will be a rule coming out in the near future about detention and demurrage. And this rule, under the statute that Congress passed, is supposed to issue this month in June of 2023. Now, it wouldn't be the first time that a federal agency failed to comply with a congressionally mandated deadline, but here we are, it's late June, we haven't seen it yet, but it's going to presumably, when it does issue, affect things such as the time within which a party must issue invoices for detention and demurrage. Will it be 30 days? Will it be 60 days, which is more customary under the UIIA? Who can a party legally bill for detention and demurrage? Do they necessarily have to have a services contract in place with the billing party, et cetera? And the agency can add to the list of these 13 data elements that I mentioned earlier. They might add, for instance, well, you got to include the bill of lading number, or you need to include the express rate calculation, or here's a URL that you can click on to get contact information. They may be issuing directives along those lines. So there could be any number of those things that happen at the FMC level, but we'll have to wait and see what the final rule looks like when it actually does issue, presumably in the near future, sometime this summer, if not this month.
Marc, thanks for walking us through a number of the big hot buttons that are out there right now. Where can people go to find more about your practice?
Sure. You can go to www.beneschlaw.com, BENESCHLAW.com. And if you're interested, they can reach out to me, or on the website, you'll see an area where you can sign up for our free newsletter that gives updates on various legal, regulatory, business developments in the transportation and logistics industry. And we send out regular bulletins as well as our well-read newsletter. So we're all about trying to help educate the industry. So check it out.
Great, Marc. Thanks very much for joining us again.
This has been a real pleasure. Thanks, Kevin. Thanks, Rick. It's always a joy to chat with you.
Thanks for joining us for InTek Freight and Logistics, the podcast. And thanks very much to Marc Blubaugh for taking the time to speak with us. Check out the links in the description to learn more about everything we discussed. Subscribe or follow now to ensure you get our latest episodes as soon as they're available. And you can help us out by rating and reviewing us wherever you listen. If you have questions, email us at podcast@inteklogistics.com and visit intekfreight-logistics.com for more about what we do. For Rick Lagore, I'm Kevin Baxter. We'll talk to you next time.